Hey everyone, Andrew Reichelson here. I'm an attorney. Now, unless you've been living under a rock, you know that former President Donald Trump, with a huge jury verdict of $83.3 million, with $65 million of that being for punitive damages. So what happens now? What can President Trump do, and what can he expect? Well, look, I've been a lawyer for quite some time. I've done appellate work. I've won a lot of appeals, and I can tell you that I think President Trump is going to win his appeal. Likely he's going to file an appeal, and he's going to win the appeal. And he's going to win it on multiple occasions. Now, one of the reasons you can win an appeal is if the judge or any of the other sides, your opposition sides, kind of something wrong or do something wrong or act a certain way in front of a jury in order to prejudice the jury against you. Now, what does he have? In late March, the judge prohibited any mention of DNA. So Trump's lawyer could not go up and say, well, look, there's no DNA at the scene. If you're going to accuse me of rape, where is the DNA? Now, also, speaking of rape, we all know what rape is. We all know what rape looks like. And Judge Kaplan, in July of 2023, he clarified that the jury had already found Trump had raped Carroll according to the common definition of that word. Now, there's a difference in the common definition and then a more scientific definition, but the common definition of that word. And that brings to mind a lot of emotion. I mean, I can't imagine what thoughts someone would go into their head when they hear someone raped someone else. It's a horrific thing, truly a horrific thing. So if you have a judge saying that you can use the word rape because of the common definition of that, Trump is not allowed to use any DNA evidence or make any kind of argument against that, well, of course, that's going to taint the jury. So he's going to argue that the jury was tainted based on those three things. There's another issue here, something called prior bad acts. So if someone committed a prior bad act, let's say they robbed a store. If they kill someone, you can't say, well, this guy's a bad guy because he robbed the store. It doesn't work like that. He has to be convicted or not convicted of the crime that they say that he did, not the fact that he did other crimes in the past. There are some exceptions to that, but most of the time in criminal law, you can't bring in prior bad acts. So on February 16, 2023, Trump's lawyer requested that the allegations from the Access Hollywood tape be barred from evidence for the reason that it's a prior bad act. It doesn't matter what he said in that tape. It doesn't matter what's going on there. This is a totally separate event, and it's a prior bad act. And the judge says, no, we're going to let that in. So the judge let in this whole information about rape, which is terrible. The judge let in the information about the Access Hollywood, which can prejudice the jury. And then, when former President Trump filed the report to have an expert come in, well, the judge rejected him because he didn't quote unquote qualify as an expert. Now, to qualify as an expert, one does not have to have a degree from Harvard. You don't have to be the creme de la creme, the best in your industry. All you have to show is that you have a requisite knowledge and skill in a particular area, and that knowledge and skill can be tested. So using the scientific method, you can test it, you can evaluate it. There is an expert report. You don't have to be a PhD. You don't have to be a Harvard grad. Now, for one reason or another, the judge denied Trump have his expert. So you have all of these things, and then you have the major defense. And the major defense is called litigation privilege. If someone sues someone else, you can say whatever you want to say within that lawsuit, even if it's a lie, even if you know it's a lie, even if it's malicious and it's a lie, but you can say it within the gambit of that lawsuit, and it's not considered defamation. It's called the litigation privilege. Because in the heat of the moment, when you're trying to defend yourself, people expect that you're going to say things, and some of those things may be true, some of those things may not be true, but you have an ultimate privilege in litigation. Now, the president's lawyer argued that you had a litigation privilege defense, and that litigation privilege defense is a bar to the underlying defamation. Because remember, this secondary lawsuit came after the first lawsuit. The first lawsuit had a judgment of $5 million. The secondary lawsuit came after that and mostly stemmed on defamation. But the argument here is it was done in accordance or within the gambit of the first lawsuit. Whether there was appeal going on or whatever have you, there was still pending litigation. It wasn't case over and shut. And because it was done with pending litigation, well, the litigation privilege attaches. Judge didn't agree with that. But that's another element of defense. So President Trump has about 4 or 5 ways that he can possibly beat this and call for a new trial. Now you have something totally different here. You have what's called punitive damages. The majority of the damages, the $65 million, it's in punitive damages. Now, what does that mean? That's damages that the jury assigns that is above and beyond what the actual damages are. The actual damages, I think they found 11 million in reputational damages and 7 million or 7.3 million in emotional damages. But then you have damages above and beyond that. Now you can get punitive damages, but you have to prove a couple of elements. You have to prove, number 1, the defendant's conduct was actionable as an independent tort. 2, the tortious conduct is gross, wanton, willful, or otherwise morally culpable. 3, the tortious conduct must be directed at the plaintiff. And 4, the conduct must be a part of a pattern directed at the public generally. So typically, those 4 elements have to be met in New York for someone to find that punitive damages are warranted, for the jury to find that punitive damages are warranted, for the judge to even allow for punitive damages to be argued. I don't know if all of those elements were met. It's likely that President Trump is going to argue that one or more of those elements were simply not met. And then you have the second question. If all else fails, now I've done a lot of appeals, and I've won a lot of appeals. And your backup argument is say, fine. Even if everything that you said is true, even if all of the case law is right, even if I lose on every single else, you still can't hit me with $65 million of punitive damages, totaling an award of $83.3 million verdict. Because it doesn't matter how much my assets are. So the plaintiff in that case, Carroll's lawyer, is essentially saying, look how rich President Trump says he is. He's a multi-billionaire. He should be hit with all of these damages. But the case law coming out of the Eastern District of New York, this case is in New York in federal court. The case law, it's the case, I believe, memory serves, In re Agent Orange product liability lawsuit. It's a case from 1983. But essentially, that case said that a defendant with tremendous assets, such as Exxon, does not face unlimited punitive damages, that due process places a limit on damages. So you have a due process issue where it doesn't matter if ExxonMobil, President Trump, some other huge conglomerate, it doesn't matter if they have tremendous amounts of money. And that's actually the language of the court in the Eastern District of New York, quote unquote, tremendous assets. It doesn't matter if they have tremendous assets. We're not trying, there's a due process issue here, and that due process issue limits the amount. Now in Florida, where I typically practice, it's typically a 3-to-1 amount. So you can't have punitive damages greater than 3 times your actual damages. So if your actual damages are, $50, you can't get more than 3 times that $50. And so on and so forth. Now there are exceptions. Clearly there are exceptions. But the general rule, the hard line rule that a lot of judges and juries and appellate courts go by is this 3-to-1 ratio. Now in my research, I couldn't find that 3-to-1 ratio being in New York. Because remember, even though this is in federal court, they're using New York state law to resolve this. I think that President Trump has multiple avenues of defense on the appeal. And I think it's very likely, depending on who the appellate courts, depending who sits on the appellate court, I think it's very likely that he'll either get a new trial or get the amount substantially reduced. Now, I'll say this. A lot of the times, justice isn't fair. And a lot of the times, the courts aren't fair. And especially the courts aren't fair when you have a political figure. The reality is the appellate court is manned by judges, just like the lower tribunal was manned by judges. And judges make mistakes, and judges have political leanings. And if you can find a case saying one thing, you can find a case saying something else. You have this rule called stare decisis, this system that we have in the United States, which is the best system. The United States truly has the best system, but it's based on precedent. And what does that mean? It means that if someone said it before, it carries some weight, especially if it's a higher court. Maybe it could be even a different court. It's still very persuasive to this particular court. So if I can find a case, for example, like the Agent Orange case that I cited to you guys, if I can find a case that says that a defendant with tremendous assets can't be hit with a tremendous punitive damage because it's a due process concern, the Carroll team will probably find 5 other cases that say something different. And then the Trump team will find more cases that say something that along the lines of what they want. And then it's up to judges, human beings that are influenced by emotion, that have their own lives, that have their own political beliefs, to make a judgment, to make a call. And that's really where the rub gets. That's really where things kind of get into the gray area, because judges are supposed to be impartial. But judges aren't robots. And judges have their own thoughts and their own feelings and their own political beliefs. And a lot of the times, most of the times, I would say probably 90% of the times, that's my opinion, that belief sinks in. So what happened? For example, today, I won a case. It's nothing as big as this case. It's not as big as my other appellate cases, but it was a case. It was a small case. I won a case where the other side was arguing for a motion to dismiss because the person that we sued is in Arizona. And whatever happened in Arizona, and everything is in Arizona. But I filed a lawsuit here because my client is here. I happen to find a judge. Well, not find, the judges are assigned randomly, but this judge has a different of opinion on how the law should work. And despite the other side making a very good motion to dismiss, really good motion to dismiss, the judge said, it's a close call, it's here or there, but I'm going to side with you, Andre. Motion to dismiss denied. They've got 10 days to answer. Now, look, if I were on the other side, I would say it's unfair because I know what the law says. The judge knows what the law says. No one's kidding here. That case should be in Arizona. But because this judge has a particular belief, what do you have? You have a case that continues. So in this case, you might have a panel of judges that have a particular belief, and that might be what makes things unfair. But if we look purely at the law, now, I wasn't at the trial. I don't know what happened. I don't know the blow for blow. But generally speaking, there are at least 5 different avenues that President Trump can appeal on. He can win on all of those avenues, or some of them, and still get a new trial. Or, ultimately, he can make sure that the damages amount are reduced substantially. Now, what happens from here? Well, he's going to file his appeal, and then there are 2 avenues of the appeal. He can ask the court to stay any collections at all until a finding on this appeal, and he's going to have multiple bases on that. That was probably what I would do in that situation. Ask for a stay so the Carroll team doesn't start issuing writs of collections or anything like that, because in our system, in our legal system, the lower tribunal, even if they're wrong, if they make a decision, that decision is binding unless there's a stay, unless the appellate court says something, or unless it's overturned, again, by the appellate court. But that decision is already in. The only way that one can stop something like this from happening now is to ask for a stay. That's probably going to be the next move, filing a notice of appeal. He's got some time to file a notice of appeal. In Florida, it's if you have a jury trial, it's usually between 15 days to 20 days. I believe the exact timeline is 15 days. If it's a bench trial, I believe it's 30 days. But regardless, he's got some time to file the appeal. And then after he files the appeal, then he's going to ask for a stay to stay all proceedings in the lower tribunal, including collections, and because he is likely to prevail on the appeal, and he's going to give his reasons why he's likely to prevail on the appeal. If you're interested in this, if you want to know more about it, if you want me to go in depth into the cross-examination, the direct examination, the opening and closing arguments, did everyone do a good job? Did someone do a bad job? Did the judge do a good job? Let me know. Like, comment, subscribe, hit the bell icon. Let me know what you want to talk about. See you later. Talk to you soon.